Hi, I'm Nicole and this is episode 3 of City of Elmhurst Hooplah. If you've made it this far, you probably know what the story is all about, but in case you want to catch up with any of the details from episode 1 or 2, I'll put links to them right up here in the upper right hand corner. Be sure to hit the subscribe button below and hit the bell so you can be notified when I upload future videos. And if you're interested in more details or the timeline, head over to our website at elmhursthooplah.com. All right, let's get into it. So, picking up from where we left off at the end of episode 2, there was the question of how's the City of Elmhurst going to address our temporary backyard hoop house? Would they choose to regulate it as a permanent structure, like a single family home like this? Or would the city be willing to amend the existing temporary special use permit, which already covers membrane structures and hoop houses just like ours, to allow for using these structures as gardening implements? Or the city could consider our backyard temporary hoop house in the context of so many other unregulated backyard devices which people use, like we've discussed: ice rinks, trampolines, jungle gyms, etc. So which one did the City of Elmhurst go with? Well, of course, they picked permanent. So they would apply the permanent building code to our temporary hoop house. So in making this determination, the City of Elmhurst applied one single line of code from their permanent building code to our situation, namely, membrane structures shall not be permitted. We understand this in the context of permanent buildings. However, the City of Elmhurst actually writes permits for temporary membrane structures. I filed a FOIA request with the City of Elmhurst, that's a Freedom of Information Act request, for the information on permits written for 2 of the membrane structures which I'm aware of in town, which are used on a seasonal basis. These structures shown in the photo are significantly larger than ours, but they are of very similar design. So clearly, membrane structures are permitted within the city limits of Elmhurst. So some of you will point out that those membrane structures were for commercial uses, and perhaps there's some different zoning regulations for commercial versus residential. Well, that's not exactly the case in our community. All membrane structures that are used on a temporary basis are regulated under the temporary use permit. So right now, you can use membrane structures on a temporary basis with a permit in the City of Elmhurst. However, gardening is not currently listed as one of the permissible uses in the temporary special use permit code. So after researching and learning about how the code works in Elmhurst, I went to the city staff and I told them that we're really just trying to do something good here. Surely there was something we could work out, right? This is really not that complicated. Membrane structures and hoop houses are in use all over the community, all over the Midwest. Let's just work it out. The staff informed me that if I would like to start the process of amending the code, I could initiate that with a $6,500 check. The other alternative would be to find 2 aldermen to sponsor a referral to the City Council to initiate the discussion. $6,500 out of pocket to start the discussion with no guarantees, or find 2 aldermen to bring this topic to the City Council. Additionally, they suggested that I might write a letter to the city manager, the mayor, and some aldermen and express my concerns and thoughts to them. I thought that was the best idea, and so I wrote a letter. It is time for the Elmhurst City Codes to be updated to allow for benign modern gardening methods, specifically temporary membrane covered hoop houses. Lastly, because keeping codes up to date is in everyone's best interests, it should not be the financial responsibility of one individual resident to cover the expense of such updating. In response to my letter, we received an invitation from the city to an in-person meeting at City Hall. We worked out a date for December 4th 2016. I won't soon forget the date because I was very excited about participating. So my husband and I attended the meeting at City Hall with the city manager, code enforcement, and the zoning department. And we laid out our ideas and suggestions and talked about how we might move forward, and were very disappointed to find out that that was not the purpose of the meeting. Actually, the city manager had invited us to a meeting so that he might tell us in person that we had to take the hoop house down, period. But we said, wait, that's a building code that applies to permanent buildings. This is not a permanent building, and we see membrane structures all over town. So surely we can work something out, right? Words have meaning. Temporary does not mean permanent, nor vice versa. We were unable to find any resolution that day, and were ultimately told that we would take the hoop house down or they would take us to court. How can you take us to court for violating a permanent building code with a temporary structure? And while we are law-abiding citizens, we do not yield to authority that is manipulating terms to make it appear that we are out of sync or out of step with the law. So we have two issues at this point. On the one hand, the city is writing permits for temporary membrane structures while saying that temporary membrane structures are not permitted. Problem number one. Problem number two is an operational problem. If the city manager would have me believe that membrane structures aren't permitted, then why does the city allow them all over the city on residential property for any number of uses? It would appear that we're being singled out for reasons that we have not yet been able to ascertain. We left that hoop house up, and I called the media. CBS responded by coming out and doing a story. I'll place a link right here. At the end of December, we received the notice for our court date in the mail. We attended many city council meetings with our supporters to try to get two aldermen to step forward and make a referral to the city council so that our issue might be taken up for discussion. I suppose you won't be surprised to know that the judge, hired by the city, took the evidence provided by the city and the argument made by the attorney hired by the city and came to the conclusion that we were guilty. If the city had such a compelling case against us, I wonder why it is that the hearing officer chose to falsify data about our lot size and lot coverage to make it look like we were in the wrong with our hoop house by virtue of the fact that we covered too much of our lot and violated regulations on maximum lot coverage, which we never did. Remember back in episode 1, I told you that my husband is very meticulous and calculated that from the very beginning? When we realized this miscarriage of justice, I thought surely that our elected officials would step up on our behalf and say that this is not how the hearing process is supposed to work. We're supposed to have more faith and confidence in our city government officials than to suspect that a hearing officer might be willing to put forth falsified testimony to make it appear that we were guilty of something that we weren't guilty of. And so I presented a plat of survey and the arithmetic to 5 of my aldermen, as well as the city manager. How many of my elected officials or the city manager do you think stepped up to help rectify this situation? Take a guess. Put your number in the comment section below and let me know what you think. Thanks for watching, and I'll catch you on the next video.